Welcome back. In our last lesson, we looked at the default path the state provides if you die without any plan at all. Today, we are exploring a different choice. Many people decide to plan their estate without a will by focusing entirely on how their property is owned. They choose to put everything into the deed or the account title, letting the property pass automatically to the next person. This is often seen as a shortcut, and it is a choice that comes with its own set of rules and real-life consequences. To understand how this works, let's look at the most common tool: joint ownership. Imagine a couple, Sarah and Michael. When they bought their home, they titled the deed as joint tenancy with right of survivorship. In plain English, this means they both own the whole house together. When Michael passes away, Sarah doesn't need a will or a judge to tell her she owns the home. The law simply recognizes her as the sole owner. The property never becomes part of a probate estate because it bypasses the court system entirely. When an asset has a built-in transfer mechanism, like a joint owner or a named beneficiary, it often passes automatically, with much less court involvement. This sounds like a perfect solution, and for many spouses, it works exactly as intended. However, things can become complicated very quickly when we try to use this same shortcut with other people, like adult children. Consider the story of a woman named Elena. Elena was getting older and wanted to make sure her daughter, Maria, would get her house without any red tape. Elena decided to add Maria to the deed of her home as a joint tenant. On paper, Elena felt a great sense of relief. But a year later, Maria went through a very difficult divorce. Because Maria was now a legal co-owner of Elena's house, Maria's ex-husband claimed that Maria's share of the house was a marital asset that should be divided. Elena suddenly faced legal pressure and unexpected complications, which caused her to consider selling her own home to pay off her daughter's divorce settlement. This is one of the hidden risks of using ownership as your primary plan. When you add someone to a deed or a bank account, you aren't just planning for the future, you are giving up control today. Your co-owner's creditors, lawsuits, or divorces can suddenly become your problem. If that co-owner has financial trouble, the IRS or a creditor may be able to assert a claim against that co-owner's interest in your property to satisfy their debts. There is also the question of what happens to your own debts. Many people believe that if property passes by ownership, it is shielded from the bills you leave behind. That isn't always true. While the transfer is faster, in some situations, creditor claims may still follow certain assets if your remaining estate doesn't have enough cash to pay your final medical bills or taxes. Another option people consider is a life estate. This is a way to split ownership across time. You might name yourself as the life tenant, meaning you have the exclusive right to live in and use the home for as long as you are alive. You then name your children as the remainder men, the people who will receive the property automatically when you pass away. One scenario for how a life estate can be a useful tool is in second marriages. You could arrange for your current spouse to have a life estate so they always have a place to live, but ensure that your children from a previous marriage are the remainder men who eventually inherit the house. However, the drawback is that once a life estate is created, it is often difficult to unwind. If you are the life tenant and you decide you want to sell the house or refinance the mortgage to pay for home repairs, you cannot do it alone. The same is true for your spouse if you gave them a life estate. You must get the written consent and cooperation of every remainder man you named. If your children disagree with your choice, or if one of them is going through a legal crisis of their own, your hands may be tied. The final most common option is the transfer on death, also called TOD. You may have also heard of the POD, or pay on death designation, which is similar. Transfer on death normally refers to assets like real property, physical assets, or sometimes on investment accounts. Payable on death is usually for intangible items like bank accounts. It is important to note that some states do not permit a transfer on death option for some property like real estate, so it is important to check with a professional to know your options. Instead of making someone a co-owner today, you name them as the person who gets the asset later, when you die. This is usually accomplished by filling out official paperwork, whether that is a transfer on death deed for your property or a beneficiary designation form at your financial institution. Transfer on death options has a big advantage, which is the person you name generally does not gain control during your life. So they can't interfere, withdraw, block a sale, or get tangled in your day-to-day decisions. You stay in control, and the transfer happens at death. But there are some gotchas to watch out for. The first is, TOD designations are very literal. If you name Alex and Alex dies before you, what happens next depends on whether you named a contingent backup and what your state's rules say. Second, TOD transfers can collide with real-life changes such as divorce, estrangement, new children. If you don't update the designations, the asset can still go to the old name on the form. And third, minors create a special kind of problem. If your beneficiary is under 18, institutions often won't hand over accounts directly, and that can trigger court involvement anyway. So TOD is often a great tool, but one that requires maintenance. So in summary, there are 3 common ownership options people use instead of a will. 1. Joint ownership. 2. Life estates. 3. Transfer on death designations. With joint ownership structures, people often utilize it for convenience and ensure it passes cleanly to the remaining owner. But the fact they are now partial owner of the asset means it can create headaches with refinancing or selling property, and if it's an account, the co-owner may have legal access to the whole balance. With life estates, You choose who has the right to live in the property for life, and then who will get the property when the life tenant passes away. This can create a clean transfer, but it can also create friction while the life tenant is still living. With transfer on death designations, you designate who can receive the asset after your death. Some states allow for a transfer on death deed for real property, while others do not. But remember, you need to maintain those designations, especially if life changes. By watching this video, you have gained the knowledge to see beyond the simplicity of ownership shortcuts. You now understand that while joint ownership, life estates, and transfer on death designations can bypass the probate court, they have their own set of risks. If you are ready for a small, immediate step, I invite you to pull out one deed or one recent bank statement today. Look at the owner line. Does it have just your name, or does it say joint or survivorship? Just knowing how your assets are currently titled is the first step in deciding if this roadmap fits your goals. You are making an informed decision about your legacy. You are choosing to understand the fine print of ownership so that your roadmap leads where you want it to go. You're doing great. Let's keep building your plan together.